Good afternoon, everyone. Welcome to the Appellate Court. I'm Judge Bright. I'm sitting this afternoon with Judge Elgo and Judge Clark on the matter of Lift Up Inc. versus Colony Insurance Company. AC docket number is 43755. We are conducting this argument over the Teams platform, so everyone is appearing by video conference. The matter is also being streamed live on the branch's YouTube channel. I'm going to ask everybody to introduce themselves so that we can make sure we can hear and see each other. I'll start with the judges, then counsel for the appellant, then counsel for the appellee. I'm again Judge Bright.
I'm Judge Elgo. Good afternoon.
Good afternoon, Judge Clark.
Good afternoon, Your Honors. Brian Kluberdans from Wofsy, Rosen, Kweskin, and Kuryansky, and with me is Attorney David Cohen. We represent the appellants Dennis and Amy Kinman.
And good afternoon. I'm Millicent Thompson with Gefeller Laurie on behalf of the appellee, Colony Insurance Company.
All right, I can hear and see everyone okay. Attorney Kluberdans, I'm going to ask you to make sure you mute your microphone. Thank you. I can hear and see everyone okay. I assume that's true for everyone else. If at any time you cannot hear anyone or see anyone, please say so. If you get disconnected from the conference for whatever reason, please go back to the link and click on it again. We will suspend the conference until we make sure everyone is present. As I've indicated, I'm going to ask everyone to keep their microphones muted when they're not speaking to avoid any feedback or background noises. The judges are going to do the same thing. If we have any questions, we're going to raise our hands. We would ask you to recognize us when we raise our hands, so again, we can avoid talking over each other. And if you don't do that, we'll just jump in like we would in the courtroom, but we're trying to avoid that. I would ask everyone to keep their cameras on at all times to make sure everyone is focused on the argument and is still present. Although this is a remote argument and we're all in different locations, I would ask everyone to treat it the same as if we were in the courtroom at 75 Elm Street and conduct yourselves accordingly. Each side will have 20 minutes to argue. The appellant can reserve time for rebuttal. I will be keeping time, and because we do not have our light system, I will be holding up signs when you have 2 minutes left, when you have 1 minute left, and when your time is up. So with that, I think we're ready to proceed. Attorney Kluberdans, are you ready to go?
Yes, Your Honor, and I'd like to please reserve 5 minutes for rebuttal.
Great. You may proceed.
May it please the court? If Bruce Kuttner was testifying under oath, he'd offer a very different version of the December 3rd, 2016 events than the one that Colony advances in its briefs and the one to which the trial court gave credence. We know that because Kuttner signed an affidavit saying on that day he was involved in a business dispute with Dennis Kinman that escalated to the point where Dennis was suddenly steering his motorized wheelchair in Kuttner's direction. The affidavit was the basis for the amended complaint in the underlying action and alleged that in an attempt to avoid this imminent collision, Kuttner tried to divert the wheelchair to the side. In doing so, Dennis fell to the ground because Kuttner did not take any steps to protect Dennis, whom he knew was a paraplegic, who wasn't able to protect himself, and who could have suffered injuries that an otherwise healthy person might not. Most importantly, the affidavit and amended complaint say that at no point during this incident did Kuttner expect or intend to cause Dennis any harm. Now, when we as Dennis's attorneys received this affidavit, which was the first time that Kuttner made any statements to anyone except Colony about this incident, we did what any attorney would do, and we amended our original complaint to include this new and distinct theory of this case. We did so because we knew at some point Kuttner might testify to these facts before a judge or a jury that might reasonably believe them and find that Kuttner acted negligently rather than intentionally. If a judge or jury did believe Kuttner at trial, we would not be able to prevail on our original complaint because it alleged only an intentional assault. Now, despite Colony's accusations and the trial court's finding to the contrary, that reason and that reason alone is why the Kinmans amended their complaint in the underlying action. Having said that, the credibility of Kuttner is not an issue with this appeal. The question for the trial judge at summary judgment was not to decide whether Kuttner acted negligently or intentionally, and nor was it to decide which one of these two versions of this incident it found more believable. That's not the question for this court today either. The only question is whether at least one allegation in this amended complaint falls even possibly within Colony's insurance coverage. If just one allegation, even possibly again, fits within the coverage, then Colony's duty to defend its insured in the underlying action was triggered, absent a clear and unambiguous policy exclusion. The Kinman's position today is that several allegations in counts 1 and 2 of the amended complaint support the conclusion that Mr. Kinman was injured as a result of an accident that arose from a business dispute. For that reason, the granting of summary judgment should be reversed, and this case should be remanded back to the trial court for further proceedings. And before we get into the substance of that, yes, Your Honor.
So I had a question for you about something that's in the appellee's brief on page 18 and footnote 10. They make reference to a stipulated judgment that the Kinmans had with Kuttner and Liftup. And they say that as a result of that stipulated judgment, Kuttner and Liftup agreed to pay attorney's fees.
Yes, Your Honor.
Is that correct?
Exemplary damages, yes, Your Honor.
Okay, so exemplary damages, would you agree, can only be awarded in a case of intentional torts?
In this context, yes, Your Honor, that's accurate.
So if that's the case, and do you also agree that while you can plead inconsistent theories, you cannot recover on inconsistent theories? Something can't be intentional and negligent, it has to be one or the other.
I'm not sure that that's accurate, Your Honor. I think that in motor vehicle cases, someone can plead both intentional conduct and a negligent conduct and recover that way.
Can recover on both theories?
To be honest, Your Honor, I don't know off the top of my head the answer to that.
So assume with me for a moment that while you can plead inconsistent theories, you can't recover on inconsistent theories. If the stipulated judgment involved exemplary damage and therefore intentional conduct, how can you also recover for unintentional conduct?
Your Honor, this was the exemplary damages were the result of a settlement between the parties. The stipulated judgment assigned the rights, assigned Mr. Kuttner's rights and Liftup's rights to the Kinmans in the underlying action, but the recovery for exemplary damages was a result of a settlement between the parties.
What difference does that make? It's still a judgment. It wasn't that the parties reached a settlement and then withdrew the complaint. We have a judgment.
But they received a release for that. They received separate consideration. I think it was the settlement happened before the stipulated judgment. The stipulated judgment was just to assign the rights, Your Honor.
So the stipulated judgment does not include the exemplary damages?
The stipulated judgment mentions them as in it had already happened. It was not part of the judgment. The stipulated judgment says that there was a settlement for that amount. It just recognizes that. The judgment assigned the rights to Liftup and Kuttner, Your Honor.
Okay, thank you.
Yes. And so the first error I'd like to address is the trial court's holding, without really any concrete analysis, that the subject incident could not fall within the policy's definition of garage operations. And in reality, there are several facts in count 1 of the complaint that allege the possibility or that Dennis's injuries arose from a business dispute and is therefore incidental to garage operations. It's important to note that on page 22 of the brief, Colony actually concedes that dealing with a disgruntled customer could be part of garage operations, which is really all we have to show to trigger the duty to defend under this section. The specific allegations in the complaint are that Liftup is in the business of modifying vehicles to make them handicap accessible, that Dennis hired Liftup to modify his vehicle to fit his needs, that the Kinmans returned to Liftup multiple times to find the vehicle had been serviced unsatisfactorily, and that on December 3rd, 2016, on what I think was their 6th attempt to retrieve the vehicle, an argument naturally ensued about this poor service. Count 1 alleges that Kuttner was a Liftup employee, acting in furtherance of business at all times, and was only interacting with the Kinmans in connection with a business transaction. So there is no other basis in any counts of the complaint for the Kinmans to have been on the property or for this argument that ensued other than customer service related to a business dispute.
Counsel, can you help me with the exclusionary language that seems to obviate the need to even assert intentional conduct with respect to the assault and battery? That it sounds like even accidental, unintentional touching that results in an injury is excluded. And so can you just help me a little bit about how that plays itself out here?
Yes, Your Honor, certainly. First of all, the policy itself covers bodily injury resulting from an accident. When we look at what unintentional battery is, which is what the exclusion language says, the only basis in Connecticut law we can find for an explanation of what unintentional battery is these transferred intent cases that we cite in our briefs, where I might intend to scare somebody but actually batter them, resulting in injury. That's where the battery itself wasn't on purpose, it was accidental, but there was transferred intent. Or if I intend to, for example, in one of the Altieri case, throw a rock at someone, but I accidentally hit someone else, I've negligently injured that person, but because I had intent to hurt someone, a battery exists. Now, in reality, we can't reconcile these two provisions of the policy. We can't have a policy that grants coverage for an accident while also excluding coverage for an accident. This exclusion swallows up the entirety of that provision of the policy. And so,
Counselor, isn't it true that the Connecticut case law recognizes that the cause of action for a negligent assault or battery in the context of someone using or being careless or reckless, I guess careless, forget reckless, careless in causing injury in the context of self-defense. I mean, there is a state Supreme Court case that I came across that talks about that as a potential example of a negligent assault.
Your Honor, that could be a negligent assault. Those are not the allegations that we're faced with here.
Then help me understand then. What was going on? Because that's a good question. So as I read the complaint, he was, Kuttner, I guess, used some force or some measure because the wheelchair was coming at him. Now you're saying that was not out of self-defense. What was going on there exactly? Why? What was he doing?
Well, we don't know. The fact is, there's certainly no allegation in the complaint that there was any self-defense at play here, which is really the only thing to look at.
So we're just supposed to guess why he, I mean, on the one hand, you're telling us it wasn't intentional and that it was negligent. On the other, you're not able to explain to us why? I mean, he's the plaintiff, right? He doesn't know why he did it?
Well, no, I don't think.
Defendant, I guess, but
I'm sorry, excuse me. I don't think you have to guess. I think that if Colony had a question about this when it read the complaint, number one, it should have tendered a defense to its insured, and then asked Kuttner why.
Well, it could have done that, but it didn't. And so now we're left to decide whether or not your allegations are covered under the scope of the policy. And just one more before we dance around on whether or not you've in fact pled a negligent assault that would be covered by that exclusion. There's another exclusion in the policy. It's under 19F. It's on page A265 of the appendix. And so the exclusion is for bodily injury, property damage, or personal and advertising or injury arising out of F. The use of any force to protect persons or property, whether or not the injury, the bodily injury, etc., was intended from the standpoint of you, the insured, any insured, or any person, or committed by or the direction of you, any insured, or any person. Why isn't that not enough of an exclusion to capture what you've alleged?
Well, Your Honor, I think, number one, Colony doesn't argue that that's applicable here. The trial court doesn't find that that's what happened here. Both trial court and Colony say these cases are just like Bullock and Clinch, where an absolute intentional battery occurred in the underlying case. Those are the findings of the trial court. Now, I think that specific provision is meant to cover, for example, a security guard who's trying to break up a fight between two people and might accidentally harm himself, might accidentally harm someone else. That's the underlying fact in my hypothetical.
Why Why do you think that it's meant to cover just that? I mean, the language says what it says, right?
Yes, I just think that's an example of something that it could cover under this. Here, there's no allegation that in the complaint, again, in the four corners of the complaint, which is what's relevant here, that Mr. Kuttner was trying to protect anybody. Why he did what he did, we don't know. It's not alleged in the complaint. He did not make a statement about that. Colony never took his deposition to ask. So all we're left with is what's inside that complaint. And the fact is, the allegation that caused injury is that he didn't take enough steps to protect Dennis, who's very susceptible to this type of injury, Your Honor. May I proceed on that? Back to the garage operations briefly, I just like to draw the court's attention to a case that was not cited in our brief, but I think instructive on this issue. And the case is Nationwide Mutual v. Pasiak. The site is 327 Con, Connecticut 225. It's a 2017 case. The case was a declaratory judgment action where the court is trying to decide whether an employee who was falsely imprisoned at work, whether this arose from business pursuits and thus would be covered by the insurance policy. On page 248 and 249 of the opinion, I just want to quote directly from the court: altercations causing bodily injury and even death have been deemed to arise from a business dispute when the dispute giving rise to the action was business related. The court then includes a string of 7 or 8 citations to out-of-state cases with this holding, as well as to a treatise, Couch on Insurance, which tells us that liabilities in connection with workplace altercations have been held necessarily to involve the insured's business pursuits and therefore fall within a business pursuits exclusion. And so, again, that case is not in our brief, but I would think it's instructive here. And again, just to briefly touch on the accident issue, Connecticut case law is clear that, and that's the Tully case, that in order for an accident to have occurred, we need, the court examines the factual allegations to decide whether both intentional acts and intended results are present. And the court examines alleged activities in the complaint to determine whether the insured intended to commit both the acts and the injuries that resulted. Here we have an allegation that's clear that Mr. Kuttner did not intend any harm to Mr. Kinman, and that should be enough to decide the accident issue. And Judge Bright, I can't see you at the moment, but I suspect
Your time is up.
All right. Thank you, Your Honors.
You have 5 minutes for your rebuttal.
Thank you.
Attorney Thompson?
May it please the court, this is Millicent Thompson from Gefeller Laurie on behalf of Colony Insurance Company. This court should affirm the trial court's entry of summary judgment for Colony on plaintiff's March 2018 amended complaint and on Colony's counterclaim for declaratory judgment, because the amended complaint very clearly alleges a physical altercation between Lift Up's principal, Bruce Kuttner, against Mr. Kinman, which Mr. Kuttner instigated, involving Kuttner's verbal threats of physical violence that the Kinmans themselves allege Kuttner then escalated into actual physical violence. Thus, the trial court properly concluded that the Kinmans' claimed personal injuries arising from that incident could not have been caused by an accident resulting from garage operations. Further, the court properly found that the Kinmans' claims arise out of an assault and battery, falling squarely within the Colony's assault and battery exclusion. Nonetheless, the Kinmans seek reversal, even though they outright admit that they amended their complaint to comport with Kuttner's affidavit, to actually adopt his version of events, which he prepared in the context of a criminal proceeding arising from this altercation. And they seek reversal even though this court and the Connecticut Supreme Court have long ago established that liability, defense, and indemnity coverage does not exist for physical altercations simply by recharacterizing them in terms of negligence, especially whereas here the policy has an unambiguous assault and battery exclusion. I wanted to jump in on a couple of the items that came up not only today, but that are sort of nuggets in the briefs that may not be so obvious. First of all, going to Judge Bright's question on the stipulated judgment. It is clear from the stipulated judgment that an actual judgment for exemplary damages entered against Mr. Kuttner and that he has paid that amount. And that's at Appendix 152 in the plaintiff's appendix. So the only stipulated judgment that's in issue in this case at this point that remains unresolved is the $850,000 stipulated judgment against LiftUp. Yes, Your Honor. I'm sorry, I can't hear you.
I'm sorry, let's just back up for a minute. On this question of the stipulated judgment, what is, in your view, the legal significance or effect of the fact that the judgment entered and referenced exemplary damages? I mean, it was a settlement. It was not fairly litigated, for instance, among the parties and adjudicated, so it doesn't seem to fall into a collateral estoppel type of situation. But what are we supposed to do with that fact if we find favorably for you on that? What's the legal theory that, and what are we compelled to do about it?
The punitive damages are not insurable, Your Honor, and that's what these are. The fact that they
but I thought that that settlement, I thought it was. But what are we supposed to draw from that? The fact that maybe Kuttner entered into a judgment that in which it was really impossible not for him to have conceded, I guess, or admitted, I guess, in some respect, intentional conduct. Is that?
Yes, Your Honor, we bring it up in part to show that it is evidence of the fact that Mr. Kuttner and the Kinmans viewed his behavior as something beyond just negligence. They went out of their way to characterize it as exemplary damages. And from a coverage perspective, as I mentioned, there is no coverage for punitive damages. So just
as presumably they structured the settlement that way, right? So Kuttner was going to have to pick up the tab for some amount of money and be essentially stopped, I guess, from trying to pursue the insurer for that amount, and then would assign his negligence claims at the same time over to the injured plaintiffs, right?
Correct, Your Honor. Although I do want to clarify that we don't view, and we put this in our briefs, Mr. Kuttner to be insured in this case. He's not in and of himself an insured. The only way he qualifies as an insured is in the context of his work for LiftUp. And it's our position that assaulting your customer is not within the scope of your duties with LiftUp. So I just want to clarify that point as well.
Okay. Thank you. Go ahead.
I did want to also unpack just a little bit the Kuttner affidavit, which of course is part of the record. And as we've briefed and argued at the trial court level, as well as before this court, we don't believe it should be considered, given that we didn't receive a copy of it until the opposition brief was filed to our motion for summary judgment, which was over a year or close to a year after the Kinmans allegedly had that affidavit in hand and should have produced it as part of discovery. Nonetheless, assuming the trial court did consider it, which it appears to be the case, if you unpack that affidavit.
On that, Attorney Thompson, did you ask that the court not consider the affidavit as a sanction?
We did, Your Honor. It's both in our summary.
Did the court agree with you on that?
The judge never specifically said what he would or wouldn't do, but in his memorandum of opinion, he states that he considered all of the materials presented to him. So we're inferring that he did in fact consider the Kuttner affidavit. And he said something to that effect in the transcript of oral argument as well, that I've read all the briefs.
You're not arguing that the court abused its discretion in considering the Kuttner transcript, are you? No,
Your Honor, we're not.
Okay, go ahead.
So as I'm saying, even if assuming that court and this court consider the Kuttner affidavit, it's important to emphasize that he executed it again as part of criminal proceedings, and specifically an accelerated rehabilitation program as part of those proceedings. Moreover, in that affidavit, in paragraph 7, he says, I escalated the verbal dispute into a physical one by slapping Dennis Kinman's baseball cap off of his head. The next paragraph, I became upset, so I grabbed the cell phone and threatened to break this effing thing right now. Paragraph 9, I grabbed Mr. Kinman. Paragraph 10, I moved or pushed him. And then paragraph 12, Mrs. Kinman appeared to be distressed by my conduct and its consequences, which goes to the definition of assault in the colony policy. And then the next paragraph, he says that he pushed the wheelchair with Mr. Kinman in it. More importantly, perhaps, is that in paragraph 15B, he says, I will initiate no further contact with the Kinmans. Obviously, something along the lines of, protective order for the Kinmans. So this isn't about some sort of negligent conduct. This is about someone who himself admits undertook in the heat of passion some acts that involve physical altercation as well as verbal threats that caused harm physically and mentally to the plaintiffs, to the point where he had to promise not to go near them after this. Yes, Your Honor.
Attorney Thompson, the plaintiffs argue that for something to be intentional, it has to be not just the physical act intentional, but the result has to be intended as well. So why isn't what all of you read, even if we accept that that showed his sole intent, that he intended to engage in physical conduct, where is there evidence of the intended result? Or do you argue that it's not necessary to have that in order to get out of the accident definition in your policy?
We argue that it's not necessary to have an intent of both, Your Honor, and the Tully's decision, the State Farm versus Tully decision that they rely on for that proposition is an opposite, because in that case, the court was considering the exclusion for expected or intended injury, a totally different part of the policy that we have not drawn on in this case. Frankly, for the very good reason that the Connecticut Supreme Court has held that exclusion involves a subjective intent analysis, which obviously would not be appropriate for summary judgment. So we have not relied on that. We're simply saying that the definition of accident under Connecticut case law very clearly says that it's the event causing injury that it defines whether something is an accident. And this is the Hammer versus Lumberman's case, an unexpected happening. How can you call this an unexpected happening when Mr. Kuttner himself and the plaintiffs allege that he instigated this physical altercation, that he took a verbal dispute and escalated it into a physical one? How can it possibly be unexpected?
Well, because wouldn't the answer be because he didn't expect it to escalate this far, and that the underlying plaintiff would, come in his direction in his wheelchair and necessitate him to do something to avoid that contact? I mean, why must we? Why must we look at the events that preceded that to determine whether or not the events that actually caused the injury were or were not an accident?
Because, Your Honor, those same events that are pled in the negligence count, this is count 1 that we're talking about against Lift Up, the same physical events are the same ones that are then appear on all the intentional conduct counts as well. So this isn't a case where, for example, they pled in the negligence count that Mr. Kuttner was just standing there having an argument, and then all of a sudden Mr. Kinman came at him in his wheelchair. No, they acknowledge up front all the same facts that form the basis for their intentional acts claims. The same thing about slapping a baseball cap and threatening verbally with expletives, and then actually following through on those threats by grabbing the phone and throwing it to the ground. So none of that is accidental. None of those things are a fortuity. They were very much intentional acts that led to the injuries.
Yeah, but the difference is then count 3 says he picked him up and threw him to the ground, which is the intentional tort, whereas count 1 alleges that after whatever happened with the cell phone, Mr. Kinman attempted to retrieve it, and that's when the defendant accidentally pushed it out of the, not the defendant, Mr. Kuttner accidentally pushed the wheelchair out of the way and causing Mr. Kinman to fall out. So the meat of those two causes of action, count 1 and count 3, are very different, aren't they?
Yes, Your Honor, they are, except that it's telling that there are similarities, as I've noted now. That they're just recharacterizing essentially the same event. They're not saying that things happen differently. They're saying that with different adjectives, the same thing.
No,
that
one
happened.
says he picked him up and threw him to the ground. The other says he pushed the wheelchair aside and he fell to the ground.
But in that same count, Your Honor, and count one again on the negligence count, it's more than just pushing aside. He actually says he grabbed him by the wrists. And so there was an actual physical contact that occurred in the heat of this moment that also involved both physical assault, slapping caps off of heads, as well as the verbal threats and expletives that went with them.
I mean, if we can just stipulate that it's permissible to plead alternatively, why do I even need to look at the other counts? I mean, I just look at the negligence count, right, and decide whether or not it's properly, pleading a negligence claim, right?
Well, Your Honor, I mean, that's not really our case law. The case law in Connecticut says you need to consider the complaint as a whole. And yes, if there's any allegation that the law is at the same time that there's any allegation that triggers coverage, there's a duty to defend. But we've also said that you can't read a complaint in its vacuum.
Well, I don't think the case law says you have to consider facts pled in an alternative count when construing a different count. I think your point about reading the entire complaint might lend credence to your argument about you have to look at all the events that led up to this particular thing happening. But anyway, go ahead, Judge Bright. I'm sorry. I think I might have interrupted.
No, go ahead.
And Your Honors, I will just add that while I get that this is the more difficult part of all of this analysis, it's only one layer about whether coverage exists here. So if we even get to a conclusion that the first count does in fact allege negligence that might trigger a duty to defend, we're not there yet, because now those same allegations have to be that this occurred as a result of garage operations and that the assault and battery exclusion doesn't apply. So just getting past that first threshold question doesn't get the plaintiffs to coverage. And we say that there is no garage operation involved in assaulting or having a physical, threateningly verbal altercation with your client, with your customer. It had nothing to do with whether Mr. Kinman was able to operate the car, was it working right? It had to do with an argument that apparently had its roots in prior arguments, as the Kinmans themselves have actually pled. And it's very important to keep in mind that unlike some of the case law that plaintiffs cite, this policy's garage operations coverage is specifically directed to the business operations themselves, not the premises. So it's not enough that the Kinmans happen to be on the business premises to trigger garage operations coverage. They have to have actually been injured in the course of Mr. Kuttner and Mr. Liftup actually conducting garage operations. And it's very hard to say that, operations necessary and incidental to a garage business involve the kind of facts that have been alleged here. Additionally, Your Honors, there's the third layer, which is really where it all comes to a full head and a stop in this case, which is the assault and battery exclusion. And, the definition of assault specifically encompasses verbal threats. There can be no dispute here that the plaintiffs themselves have alleged a verbal abusive context of threats that involved expletives and the specific threat of physical harm to Mrs. and Mr. Kinman and the things that they were with, their cell phone, and that actually occurred. They alleged that Mr. Kuttner actually took the phone out of her hands and threw it to the ground. That falls squarely within the definition of assault.
Did you rely below, or are you relying here on 19F of the exclusions?
It is part of the exclusion, Your Honor, but no, Mr. Kinman, neither the Kinmans nor Mr. Kuttner have ever specifically alleged self-defense on Mr. Kuttner's behalf. I can see how the court is directed to that, because if you read the allegations, there's almost an implication of it, but they've never pled it, and it's therefore, although it's part of the exclusion, it's not specifically part of this case.
Okay, thank you.
Yes. Whether we actually get to whether this is a battery or not is not relevant because the exclusion specifically says it can be an assault or a battery. And in this case, as I mentioned, it's very clearly something that falls within the unambiguous policy language having to do with assault.
Why is that? Why is the assault the more persuasive exclusion again?
Well, it's a part of the same exclusion, Your Honor, but it's persuasive. It's so evident on its face because assault is defined as an intentional or unintentional act, including but not limited to verbal abuse or any threatened, harmful, or offensive conduct.
Yeah, but they're not alleging here that verbal abuse or threats are what caused the injury, are they?
They're alleging that it happened, Your Honor, and in the assault and battery exclusion, there doesn't have to be a direct proximate cause allegation. All it has to be that it arose out of. The language of the assault and battery exclusion uses the very broad phrase arising out of. So if Mr. Kinman was hurt, it was arising out of the verbal threats and follow through on those threats from Mr. Kuttner here.
So let me ask you about the unintentional, and you have about 2 minutes left. The unintentional battery piece. Does that mean, in your view, under this exclusion, any bodily injury that's caused by physical contact between the insured and a third party is excluded?
Well, that's how the exclusion reads, Your Honor. And yes, it is broad, as the trial court acknowledged, but even the plaintiffs admit at page 17 of their opening brief that negligent battery can occur when one intends to cause apprehension of harm to someone's body, but instead causes harmful physical contact.
But what if this situation that a customer standing in the garage and an employee just turns around accidentally and slams into him and knocks him over? Didn't know they were there, knocks him over, person falls, hits their head, and suffers severe physical injury. Is that an unintentional battery?
Well, it most likely is not, Your Honor, because if you read the entire language of the definition, it says that it's an intentional or unintentional act, including any actual harmful or offensive conduct. Now, obviously, the term harmful could mean that what you just described.
Counsel, that can't be right. I mean, aren't what they saying an intentional or intentional act? Then they list some illustrative examples, and then they say or any actual harmful or offensive contact between two or more persons. So it's one or the other. And in either case, if it brings about harmful or offensive contact, I'm trying to understand. It is. I mean, because keep in mind, the plaintiff's argument here. I can't keep track of who I'm dealing with. Or your opposing counsel. I mean, their argument is that I think is mostly that this is an ambiguous provision. I mean, that seems to be their primary defense with respect to this exclusion. So maybe I'm wrong, and I shouldn't have cut you off. Explain to me again what that. If you could let me finish, Judge, or have the counsel finish. Yeah. What does this actually mean? I mean, how does the harmful or offensive contact relate to an intentional or unintentional act?
Well, what I was going to say, Your Honor, is that if you read that phrase as a whole, actual harmful or offensive contact, the things that were alleged here could easily fall within that, right? And I understand the scenario we're talking about is this accidental turning around and hurting your customer. But I think that it's not ambiguous if you read the phrase as a whole and you see that those words, harmful and offensive, in the context of the exclusion as a whole, demonstrate an intent that there have been, something like what happened here, not just an accidental turning around, but an actual, altercation of some sort that led to a battery. And ultimately, it doesn't matter in this case because, as Judge DeAndrea said, at a minimum, there was an assault in this case. At worst, there was a battery. So all this court has to find is the assault, which we've clearly demonstrated was there.
Okay, thank you, Attorney Lubridan. So you have 5 minutes for your rebuttal. You're on mute.
Thank you, Your Honors. For some reason, I can only see the person who's talking. So if you have questions, please just interrupt rather than raising your hand, and I'll stop where I am. I just want to pick up on what Judge Clark just mentioned there, that absolutely our argument here is that this policy language is, at best, ambiguous. This Judge Bright's example is spot on. If, to use an example Colony uses in its brief, if Dennis Kimmon had been struck by a car that Colony was servicing, clearly an accident, clearly something that's meant to be covered in an insurance policy, Colony could turn around and say that this was a battery and not covered, even though the policy itself provides coverage for accidents resulting from bodily injury. The fact is that this exclusion is it's completely irreconcilable with the effort by Colony to avoid cover, to grant coverage for injuries, for bodily injury. There's just no way we can expect that Kuttner or Liftup bought a policy thinking that these types of accidents that could not be covered. And the case law is clear that when there are ambiguities in a policy like there is here, they must be construed in favor of the insured. And for that reason alone, we think that this assault and battery exclusion is untenable here. I want to point out that when Attorney Thompson was reading from the affidavit, she leaves out the allegation that was then adopted into the amended complaint, saying that Mr. Kuttner did not expect or intend any harm to Dennis. Intent is absolutely relevant when determining whether an accident occurred, and it's relevant to determining when an intentional assault or battery occurred. So
let me ask you a question. Let's say we have a true battery where the person, Kuttner, says, yeah, I wound up and I punched him in the shoulder, but I didn't intend to hurt him. All I was trying to do was get him to back off. So I punched him, and that doesn't constitute a battery, or that's still an accident because the injury wasn't what I intended. Would that work?
No, Your Honor. There are cases that say where the harm that's caused is so predictable or so easily anticipated, that is not an accident. And it's cited in our brief. It's in a footnote. But I'm not going to be able to find it.
That's okay.
It's cited in there for that exact example you're giving, Your Honor. I just finally want to point out that the Clinch and Bullock cases that are so heavily relied on by the trial court and by Colony they're not what happened here. In both of those cases and both underlying cases, there was clearly intentional batteries and so when
you have 2 minutes.
Thank you. When Colony says we have to read these complaints as a whole, the reason why it was so easy in those cases is because there was only one way that the injuries happened. In this case, we have two very distinct theories of how Mr. Kimmon's injuries happened, and that's why reliance on those two cases was inappropriate by the trial court. And I'd just like to wrap up by saying what really should have happened here. If Colony was truly concerned that Kuttner's affidavit was not credible, the right course and what Colony did in the Halpern case, what the defendant did in the Bullock case, was to defend the case under a reservation of rights, file a declaratory judgment action, and litigate these issues to find out whether they had to indemnify. They could have resolved all of those issues here. So, if they were so concerned with being not credible. That's not what happened, and now we're left with the four corners of the complaint comparing them to the policy. And for those reasons, we think that the trial court got it wrong, and we ask the decision be reversed and remanded back to the trial court.
All right. Thank you both for participating in the virtual courtroom today. We will take the matter under advisement, and we will stand adjourned until 9:30 tomorrow morning. Thank you. Have a good evening.
Thank you, Your Honor.
You as well.